Morning. My name is Hayward Dykes. I'm the magistrate. I'm going to call to order the February 11th, 2026 magistrate docket to order. We have two items to deal with on the docket. The first one is, I'm going to mess up this name, Shankanglory Beard. Okay. So, Miss Beard, if you want to come up, you can take a seat here at the front. And then anybody who plans to present testimony or evidence this morning, will you please stand and raise your right hand? That would include you, Miss Beard. Thank you. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. You can have a seat. And Miss Beard, the way we're going to do this is we're going to allow Officer Esquivel to present. You'll have the opportunity to ask him any questions, and then after he presents, we'll give you an opportunity to present any evidence or testimony you would like for me to consider this morning. All right?
Which one is the? Okay, there's like three of them here. That's why. But I have packets of the evidence for you, sir, and for.
All right. Yeah. Well. If you want to go ahead and pass that out.
But on the 3rd of October of last year, we received a complaint of a vehicle being parked on a sidewalk, which is a violation of ordinance number 2050 and 2021. This was before we revised the chapter. And when I got there, I did see the vehicle that belonged to Mr. Sina parked on the sidewalk, and I just issued a citation on that. As if you can see on the pictures, there's multiple pictures of the vehicle being parked on the sidewalk, a copy of the original citation I wrote that day, and as well as the ordinance 2050 and 2021, which references the Florida statute that we use for sidewalk and multimodal violations, which is 316-1945. And I have it highlighted for you there on the packet of why I use that ordinance to cite Miss Beard.
Okay. I have a copy of the photographs that were presented, as well as a printout showing that the 2023 Ford Bronco title holder as Dallas Chad Beard. Okay. And a copy of the citation that was apparently left on the vehicle, the state statute, as you stated, as well as the applicable county code. All right. Do you wish to put this into evidence?
Yes, sir.
Okay.
Yeah, I would also like to point out that I did use Miss Shasina. As you can see in the motor vehicle report, she has a Walton County address that's why I used that.
Okay. Yeah, I see there's a Franklin, Tennessee address for Mr. Beard, and then for Mrs. Beard, a Santa Rosa Beach address. Okay. All right. I'll accept the packet into evidence as County's Exhibit 1. I'll ask Ms. Beard, do you have any objections to me accepting that into evidence? Any issues with that? Okay. Yeah, I'm going to let you. Do you have any is that it, Officer Esquivel?
Yes, sir.
All right. Do you have any questions for Officer Esquivel? And if you do, I would just ask that you come up to the microphone. Okay. Officer Esquivel, you can grab a seat. Thank you, sir. And Ms. Beard, if you want to go ahead and come up to the microphone, we do record these. And this will be your opportunity to present any evidence or exhibits, testimony, anything that you'd like me to consider.
Well, the only exhibit or evidence, can I hand this to you?
Sure.
Is
Well, do this. Show it to Officer Esquivel so he can see what you're handing me. Okay. And, all right. So, yeah, if you want to go by the microphone. So Ms. Beard handed me a sheet of paper that has 2 photographs on it. And do you want to go ahead and explain what we're looking at?
So, I mean, normally, if I thought this, that this wasn't wrong, I wouldn't be here. I just pay the parking ticket. And honestly, after looking at your evidence for parking, I was at my house and just wanted to move my car out of my driveway for a little bit to take photos, for short-term rental photos, and parked over, and I thought I was being observant of the road and all with parking in the little cutaway thing. I didn't realize I was than I realized. But so I went in, I took photos and was doing something around the house and came back out and was surprised. It was a very low time of the year. There's not hardly anybody there. I'm across the street from my house for a little while and take photos and get a parking ticket. If you know, there's a person or a neighbor in our street that lobbed themselves up to be the jury for everybody around us. And it was a very unneighborly thing and seemed like bringing you guys in when it's something that should be handled that big of a deal to them. So that's where I can come to you and
Okay, thank you, ma'am. You want to enter this into evidence, I'm assuming? All right. We'll mark this as Ms. Beard, Defendant's Exhibit A. All right. Any other evidence or testimony, Ms. Beard, that you want to present this morning? Thank you, ma'am. Officer Esquivel, do you have any questions for Ms. Beard? All right. I'll go ahead and close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that based on the testimony and evidence presented this morning that there was while the violation was denied, there was sufficient evidence to prove that a violation occurred. I'm going to find that a violation of the infraction as charged was proven. Ms. Beard, these are what's called kind of like strict liability crimes. So it's almost like speeding. You know, you either did it or you didn't do it. I believe the evidence presented by Officer Esquivel and your own admission show that there was parking on the sidewalk. And even though it was, I don't dispute your claim that it was for a short period of time. There is no period of time that specifically allowed in the statute. So if that were the case, then I think we might have a different outcome. But at least this morning, based on the testimony and evidence presented, I must find that there has been a violation. In this case, because of the violation, there is a $100 fine, $50 administrative fee, and a clerk processing fee of $25 for a total of $175. Ms. Beard, can you pay that within 30 days? Okay. I'll give you 30 days to pay that. That will be paid at the clerk's office, so you can either pay it at the south end or the north end based on your address. I believe the south end would be most convenient for you, and you will be receiving a copy of your order from the clerk. I appreciate you coming in, Ms. Beard. I understand you had to take time out of your day. Good luck to you. Have a good day. You're done. All right. And our next case is the Scott Weatherford case. And this is a matter where, well, I'll just have the county go ahead and put on the record what we're doing and why we're doing it. All right, whenever you're ready, go ahead.
Good morning, I'm Code Compliance Parking Supervisor Georgina Hicks, and for the record, I'm presenting and testifying in reference to parking citation number CE 06654. While patrolling at the Dune Allen Regional Beach Access, Officer McClellan observed and cited an LSV, low-speed vehicle, parked in the county parking lot with an expired tag, CC08LF. The tag had previously been assigned to a low-speed vehicle that was sold to the respondent, Mr. Scott Weatherford. Mr. Weatherford, after he purchased his LSV, he registered the LSV with tag RLET65. It was later determined through investigation by Code Compliance that the other party had attached the expired tag CC08LF to a different LSV and rented it out. There was no visible VIN number on the LSV for Officer McClellan to compare it to, so the citation was issued to the respondent. The respondent, in this case, paid the citation out of abundance of caution prior to informing Code Compliance, and so that's what's requiring the matter to come before you today for relief. Code Compliance is requesting that the case be dismissed against the respondent, and the $125 paid citation shall be refunded to the respondent in full.
And with that being said, I've got a copy of the citation that was issued to Mr. Scott Weatherford, dated October 6, 2025, for expired tag / registration, photographs of what I can only assume is the LSV with a license plate picture as well, and then an email from Miss Hicks advising of the error. All right, I'll accept that into evidence as part of the request for dismissal of the citation and refund of the previously paid fine and administrative fee. I have a pre-prepared order that shows that the refund would be for $125. Is that correct?
Yes, sir.
Okay. All right. Based on the testimony and evidence presented, I will go ahead and dismiss the citation, order that the refund of $125 previously paid by Mr. Weatherford to the county related to citation CE 06654 shall be refunded in full. I've signed that, and we'll make that Exhibit A. Or I'm sorry, Exhibit 1 for the county in this matter, so we have a record of what occurred and why we're doing this today. All right, I've signed that order, and it does need to be notarized. I think it's got Gina listed as notarizing it. So, I don't know that we need it notarized, but it was on there. So, all right, does that conclude that matter?
Yes, sir.
All right, that's the last thing I have on my docket, unless there's something else. All right, it's 10 o'clock. I'm going to go ahead and call to order the Walton County Code Compliance Hearing Meeting to order for February 11th, 2026. My name is Hayward Dykes. I'm the special magistrate. We'll be hearing the cases this morning. If you have a cell phone, please either turn it off or put it on vibrate. If you have, we will, at this time, if you can, please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. You can be seated. I've reviewed the minutes from last month and have those signed. Are there any announcements that need to be made? All right. At this time, anyone who plans to present either evidence or testimony related to any of the cases that we have on the docket or on the agenda today, if you'll please stand and raise your right hand. Do you all swear or affirm to tell the truth? Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? All right. Thank you. All right. With those being taken care of, our first case is CE 22-00816. This is a fine reduction case for Cross Point Church of Point Washington. Do you have a representative here for Cross Point Church? Okay. If you want to come on up, you can grab a seat up here to my left at that table. This is for everybody as well. If you decide that you need to speak or present any testimony, please make sure to come up to the podium. We do record these and put them on YouTube, so we try to capture what people are saying. All right, and all right, Officer Hicks, whenever you're ready.
Good morning. I am Code Compliance Officer Georgina Hicks. For the record, I'm submitting a final summary and report and presentation and testimony to reference to case 22-00816. This property is in the unincorporated area of Walton County and subject to the Land Development Code Chapter 7. The property is located at 1144 North Highway 395 in Santa Rosa Beach, Florida. This property owner is listed as Cross Point Church of Point Washington, Inc. On 5/31 of 2022, a complaint was called into our office for a dilapidated structure. Inspection of the property showed that a house was on I-beams and for transport. The house was set there without a development order. The property was found in violation for 1.1300A development approvals on August the 14th of 2024. And the property owner was ordered that the property be brought into compliance within 90 days on or before November the 12th of 2024, or a $250 per day fine would be imposed with an $88 administration fee. Property owner was not able to obtain compliance by the deadline, and an affidavit of noncompliance was issued on November the 12th of 2024. November 21st, the property owner had the house removed from the property, which brought the property into compliance. An order of imposing fine was signed by Magistrate Dykes on December the 11th of 2024, ordering that the property pay $2,250 for the fines that had accrued after the deadline, and that no additional fines accrued because the property was now in compliance. Fines imposed were the $2,250, and then the admin fee has been paid. So just the order of imposing fine is what's outstanding. The property is being brought before you today because the property owner is requesting a fine reduction. The county has no objection to a fine reduction.
Okay. It's my understanding the county doesn't oppose the fine reduction, but it has no recommendation as to what the amount should be reduced, or what's the applicant requesting?
No, sir, I don't know what the applicant's requesting.
Okay. Who do I have for the church?
Morning, my name is Ono Horn, H-O-R-N. I'm here on behalf of the church.
All right. And what's your position with the church?
Well, my position would hopefully be to let you know the house has been moved, and in our last hearing, you had possibly mentioned some opportunity to extend our requested 90 days to 120 days, which wasn't granted at the time, but you said, I think administratively, you're only limited to a 90-day window, but the 30 days would be possible. So I think we're in just a few days and respectfully requesting a fine reduction.
Okay. Well, yeah, you're correct in that.
I think there was an administrative,
My understanding is I can provide up to 3 months for someone to bring their property into compliance.
Correct, yeah.
Which it appears I gave the maximum allowed time. So what's the, on behalf of the church, Mr. Horn, what are you requesting that the fine be reduced to?
If possible, we would request, the fine be reduced to maybe $500.
Okay.
Had some limitations with working with the house mover and his schedule, and I think we were close, but just didn't.
All right. The, anything else that you want to? All right. I appreciate it, Mr.
Yep, I
Horn.
appreciate it. Thank you.
All right. Anything from the county related to Mr. Horn's or the church's request to reduce the fine? That's approximately just under 25%, so probably around 20% of the accumulated fine. All right. Anything else for me to hear, county, or from the church or from the public? All right, not seeing anybody, I'll go ahead and close the evidence portion. Based on the request and no objection by the county, I will grant the fine reduction. The fine will be reduced to $500 as requested by the church. How quickly can the church pay that? Will y'all be able to take it today? Or will you need till tomorrow?
Sir, it'll more than likely be recorded today, and that it'd probably be tomorrow before he could be able to access those records with the clerk. We do ask that you stipulate that the fine be paid within your stipulated time, or it would be returned back to the original amount ordered.
Correct. That's part of the order. I was about to announce that. So what I'm going to do is I'm going to give you 30 days to pay. So be aware that if you do not pay the fine within 30 days, the fines will automatically go back up to the pre-requested amount. So right, after you pay the reduced amount, then the order will show is satisfied. All right, I've signed the $500, 30 days to pay. So I would just recommend that you maybe consider looking to just handle that maybe in the next 24 to 48 hours, so they'll have it in their system. Right? Any questions? All right, thank you. You're dismissed. Next case is CE 22-00961. Property owners are listed as Mark and Tia Shubert, Shubert, and this is also a fine reduction request. Officer Hicks, whenever you're ready.
Good morning again. I am Code Compliance Officer Georgina Hicks, and for the record, I'm submitting my final summary and report presentation testimony in reference to case 22-00961. This property is in an unincorporated area of Walton County and subject to the Land Development Code Chapter 7. The property is at the corner lot of Nautilus Court and Shelter Cove in Miramar Beach, and the property parcel number is 242S21-42311-000-0210. The property owner is listed as Mark and Tia Shubert. On 7/13 of 2022, our office received a complaint from multiple construction trailers being stored on a vacant lot. Inspection of the property showed a Connex box, equipment, and construction materials that were being stored. The property was found in violation for 1.1300A development approval on January 18th, 2023 by Magistrate Dykes. The property owner was ordered that the property be brought into compliance within 60 days on or before March 19th of 2023, or a $100 per day fine would be imposed with a $98 administration fee. The property owner was not able to obtain compliance by the deadline, and an affidavit of noncompliance was issued on March 19th of 2023. An order imposing fine was signed on June 21st, 2023, ordering the property owner to pay $9,452 for the fines that accrued after the deadline, and a continued amount of $100 per day until the property obtained compliance. The property was brought into compliance on February 9th, 2026, and an affidavit of compliance was completed and recorded the same day on February 9th. Total fines imposed and accrued totaling $105,700, and the administration fees were paid that were ordered on the final order. This property is being brought to you today because the property owner is requesting a fine reduction, and the county has no objection to a fine reduction.
Are you Mr. Shubert?
Yes, sir.
All right, Mr. Shubert, if you want to come up, and I'll hear what you want me to hear is mitigating circumstances on your request for the fine reduction.
Yes, sir. I went to court and they told me I could build on it. So I started the process to pull permits. And my grandmother fell, so I went to Georgia for 9 months to take care of her. Came home, got another permit, and then started a divorce. And the court said I couldn't sell anything, and the only way to get rid of the Connex and stuff like that was to sell it. And I just begged mercy of the court.
Okay, do you have anything that you want to present? I mean, understand, you know, you had a sick mother and sounds like you had some personal things that prevented, but we're looking at over 1,000 days of non-compliance. What are you requesting that be reduced to?
$10,000, $15,000, just
Okay. Does the county have any comments related to the request?
Stipulation on the 30 days, or the time frame that you ordered to be paid within that time, or back to the original amount.
And this was, just so I'm clear, and I do vaguely remember this case, it was the trailers and the Connex box. So yeah, I mean, I guess what I'm getting at is it didn't seem as though much of it was maybe the Connex box. Were there 2 Connex boxes or just one? Okay. Yeah, most of it appears to be things that could have and probably should have been easily removable beyond the Connex box, but even that. So I'm trying to find out how long would it, I haven't decided on whether I'm not, but in the event that the fine is reduced, and some of it may be based on the amount that it's reduced to, how quickly would you be able to pay?
I closed on a house Friday, and they're going to take the money from that, is my understanding,
Okay.
from the divorce.
All right. All right. Anything else, Mr. Shubert? All right. I appreciate you. You can grab a seat. All right. At this time, I'll close the evidence portion. Based on the testimony and evidence presented, and without objection from the county, I will order that a fine reduction is appropriate in this case. Because of the length of time, I will reduce the fine to $15,000. Mr. Shubert, I'll give you the same amount of time. I understand you said the closing is going to happen fairly quickly, but I'm going to go ahead and give you 30 days. Do you believe that would be, just in case there's an issue with the closing, or would you like 45? Okay. Then I'll give Mr. Shubert 30 days The reduction will be to $15,000. In the event the reduced fine is not paid within 30 days, similar to the last individual, the fine will automatically go back up. So there won't be another hearing. It'll just go back up after the 30 days. So just be aware of that if something happens with your closing. All right? Do you have a question?
Closing, they won't take $105,000.
No, the order will be signed. What I recommend is you probably have the title company or ask someone from the county to transmit that to the title company. And then that way they'll have that. They'll need to confirm that through the county though. That won't involve me, but with the fine reduction and them confirming that they're going to accept the $15,000 in lieu of the $105,700, that should be sufficient for your title company. But that'll be something they'll need to figure out so their underwriter and everybody's happy with that. But hopefully that will be enough for them. Yes, sir. All right. I've signed that order. Mr. Shubert, good luck to you. Thank you. Our next case is CE 25-01-448. This is WPRE Ventures 1 LLC. This is also a fine reduction. Officer Neenan, whenever you're ready. Oh, do we have somebody here for?
I was told that they were going to be here from Chicago.
Okay.
See anyone?
Anybody's up here. Have we heard anything? Do we know if someone's on the way?
Reached out after they requested the fine reduction.
Okay. Well, it might be, I've got on this discount lots.
Yes.
Okay,
He's
so
here.
on the agenda, we have WPRE Ventures, but on this draft order is Discount Lots LLC. Are you here? Okay, are you here for, are those one and the same, or was it sold or something, or?
I believe they're both the same entity. They just have the same owner, but two different LLCs, and
Okay.
one bought the other one during they transferred names during a foreclosure.
Okay, and what's your name, sir? All right, Mr. Cothran. Yeah, he can maybe sort that out. Like I said, that's why, I guess what I'm asking is, should it be Discount Lots LLC or should it be WPRE Ventures 1 LLC?
I actually have an order for both, just in case, depending on how you would prefer it be written on your order.
Well, the original order
Is the-
imposing fines, finding the violation and imposing fines was against WPRE Ventures 1 LLC.
Correct, yes, sir.
So, well, let's do this. Go ahead and present that, and I'll let Mr. Cothran educate us on which one might be the better one.
Okay. For the record, I'm Officer Rachel Neenan, Walton County Code Compliance. I'm submitting my final summary case report and testimony regarding case number 25-01448. The property is located at lots 15, 16, 40, and 41, Block 38, Oakwood Hills, West Big Cypress Drive in Defuniak Springs, Florida, 32433. Parcel number is 15-3 North-20-28070-038-0000. Discount Lots LLC, as of January 5th of 2026, had purchased the property, and the property is now under a new name. This property is in the unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7, and the county ordinances. A complaint come in that there is a camper and 2 sheds on the property with people living in them with no water or sewer hookups. This case was heard before you on August 13th of 2025, where the property was found in violation of 1.13.09C building permits, 5.0709C non-operating vehicles and junk and debris, 2.02.00P RVs and campers, and 1.1300A development approvals. The property owner was given until September 12th of 2025 to come into compliance, or a $250 per day fine would be imposed. An affidavit of noncompliance was completed on September 12th of 2025 and recorded. The property owner was able to obtain compliance on November 20th of 2025 and was recorded on December 2nd of 2025. At this time, the total fines is $17,250. The county has no objection to a fine reduction. There's also an administrative fee of $23.
Was that from the original, the $23?
No, sir, it's for this this case here. Would you like me to bring up the other order for WRE Ventures just in case you want to decide between the two?
Well, I was looking at the property appraiser's website, and it looks like there was a certificate of title issued to discount lot. Let's see.
Yes, sir. I put the warranty deed and those things in your packet.
All right. Thank you, ma'am. All right, Mr. Cothran. What would you like me to hear in reference to the fine reduction?
Your Honor, I believe that with the LLC, I believe they dissolved the initial one and quitclaimed it to the discount lot. So that is who I'm here representing.
Okay.
Lots. Their position on this is that they would respectfully ask that the fines be waived because the violations were committed by squatters who were on site when they bought the property. They went through the process, got a court order to evict them. That took about a year, and they removed the squatters, cleared the property, brought it into full compliance. They've paid the administrative fees, and they acted in good faith at every step. So they would ask that the fines be reduced to 0.
So the certificate of title was issued January of this year. The what was that court case about? Was that, it doesn't look like it was an eviction.
That one.
Well, I will tell you that I'm reluctant to take the fines to 0. So hold on 1 second. I'm trying to pull up the case docket. So the matter was originally filed in the circuit court as a foreclosure action. Property was sold and a certificate of title was issued after foreclosure. All right. The with Mr. Cothran, with my statement earlier that I'm reluctant to reduce the fines to 0 or waive them as requested. Do you have another request? And you may not have authority, which is fine, but I can, and if you need time to call Discount Lots LLC or speak to somebody else, I'll give you that time to do that. If you want to give me a proposal, otherwise I'll come up with a number, and then as we've done with others, you'll either pay it within the time provided, or it'll just stay at the amount.
Okay. Would $500 suffice?
Is that what you're requesting?
Yes, sir.
Okay. Does the county have any requests or comments as it relates to the fine reduction requested? Okay. All right. Thank you, sir. You can grab a seat. I'll close the evidence portion of this hearing. I'll find that based on the evidence presented and with no objection from the county, a fine reduction is appropriate here. It appears to me that Discount Lots LLC would be the beneficiary of this since they're the current owner, so that's the order that I'm going to sign today. I think if there's some other reason that we need an order for WPRE Ventures 1 LLC, I don't know that anybody's presented that. I mean, any fine reduction, Mr. Cothran, you believe would be appropriate for Discount Lots? All right. And I'm in agreement with that. So Mr. Cothran has requested on behalf of the Discount Lots LLC for a $500 fine reduction. I do find, now I will say that the lawsuit that was filed in this matter was May 23rd of 2025. The affidavit of noncompliance shows that this matter began, or the hearing that we had was August 13th, 2025. So at least at the time that the code case came before myself, it appears that there was some attempt to get the matter moving, at least through the court system. And being familiar with the court system, I understand that things don't move rapidly, or as rapidly as we sometimes hope. With all that being said, I do think a $500 reduction is too low. I will reduce the fine to $1,500, which is less than 10% of the accumulated fine. That amount, in addition to the $1,500, there's a $23 administrative fee that will also need to be paid for a total of $1,523. The reduced amount, do you need longer than 30 days, Mr. Cothran? All right. So 30 days to pay the $1,523. In the event the reduced fine is not paid, then the original amount will be automatically reimposed. That amount again is $17,273. And I've signed that order. All right. That should resolve that matter. Mr. Cothran, as we told others, probably wait about 24 to 48 hours before you attempt to pay that. All right. Thank you, sir. You're dismissed.
Perfect. Thank you.
The next case is case number 2302728. Property owners are listed as Sylvia and Luca Sargraves, S-A-R-G-R-A-V-E-S. Are you Mr. Sargraves? All right. And Mr. Sargraves will allow them to present, and then I'll hear from you, all right? Officer Neenan, whenever you're ready.
Officer Rachel Neenan, Walton County Code Compliance. For the record, I'm submitting my final summary case report and testimony in regards to case number 23-02728. The property is located at Jones Drive, Freeport, Florida 32439. Parcel number 22-12-2303000000190. Property owner is Sylvia and Luca Sawgraves. Saygraves. This property is in the unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7, and county ordinances. We received a complaint that they were building on a vacant parcel. This case was heard before you on April 17th of 2025, where the property was found in violation for 1.13.009C building permits and 1.13.00A-F clearing permits. The property owner was given until July 16th of 2025 to come into compliance, or a $75 per day fine to be imposed. An affidavit of noncompliance was completed on April 17th of 2025, and the property owner was able to obtain compliance on February 3rd of 2026. An affidavit was recorded on February 5th of 2026. The total fine was $15,150 with an admin fee for today's hearing of $23. The county has no objection to a fine reduction.
Thank you, ma'am. Refresh my memory, this was failure to have permits, is that correct?
Correct, yes, sir. He removed everything off of the property and returned it back to vacant status.
And was that through a restoration plan with the county? Or do you know?
I'm sorry, I misspoke. It was not clearing permits, it was development approvals.
Okay, yeah, that's what I was
Yes, sir.
questioning, is
I
it was for
misspoke.
failure to have development order.
Yes, sir, and building permits.
And then that wasn't resolved for 567 days.
Yes, sir.
All right, thank you. Mr. Sawgraves, I'll be glad to hear from you. I know someone else sat beside you. I don't know who that gentleman is or if he plans to speak. I'll be glad to hear from you. Yes, sir.
Morning, Magistrate Dykes. My legal counsel suggested I give you this note.
Yeah, you want to show it to the county first, or if you have a copy for them? Yeah, yes, sir. Hold on one second. Do you want to give me all of this, or just, because some of this looks like it's...
This is what you really need to read.
Okay,
This is my earning.
Okay.
My owner from here.
okay. Well, I'm going to give that back to you because I don't want this being part of the record, but go ahead and, if you don't mind, going back to the microphone so we can capture this. And then you said this was a letter from your attorney, or is this this looks like a letter
It's
from
just
you?
legal counsel. They didn't sign it, but that was at their suggestion.
Okay. Oh, it's not on any letterhead, but I'll go ahead and take a look at it. Hold on. Okay. All right. I'll accept this into evidence as part of the request for your reasoning for your fine reduction. And just, does the county have a copy? Did he give you a copy? Okay. So, in short, I mean, I'll be glad to paraphrase this if you want it on the record, or you can just,
That's fine.
however you want to do it. You want me to?
I don't have a copy in front of me now to read it, but you can.
Yeah, I
paraphrase
mean,
if you
it
like.
looks as though you mentioned that the shed has been removed from the property, was never a threat to the community. The violation is cured, which obviously, otherwise we wouldn't be here. That it's, are you in the process of trying to sell the property currently?
Yes, sir. That's why Mr. Thompson's here.
Okay. Is Mr. Thompson the purchaser, your realtor? Okay. All right. And the, okay, so you're requesting, at least at this point, from what the letter says, a fine reduction of 90%?
Yes, sir.
Okay. And the basis of that?
The property's back in its original state. There's nothing there other than trees and grass.
No, I understand that. So the current accumulated fine is $42,525. Why did it take so long to bring it into compliance if it was a shed and then letting it go back to its natural state?
I was in between living situations, and I had to rent a room for that period of time. Since that time, I've moved to Calhoun County, and I just don't get an opportunity to come over here and straighten things up very often.
Okay. So it was just you didn't have the time to get over here and resolve the issue?
I had stored clothing, books, and furniture in the shed, and it just took me that long to buy another house to move my belongings to another structure.
Okay, understood. All right, so based on the letter and Mr. Sawgrave's testimony, it appears he's requesting a 90% reduction in the $42,548 fine, which would put the reduced fine at $4,254.80. Does the county have any comments or want to be heard before I decide on this matter? Okay, thank you. Anything else, Mr. Sawgraves?
Due to my limited income, I could afford to pay. I'm suggesting $2,000.
Okay. All right. Anything from the county on that? Okay. How much is the property being sold for?
I think Mr. Thompson's offered approximately $50,000.
All right. Is the property set to close soon, or is it based on?
As soon as I get it cleared,
Understood. All right. All right. Anything else?
No, sir.
All right. Thank you, sir. You can grab a seat. All right. At this time, I'll close the evidence portion. I'll make the following findings of fact and conclusions that of law. I'll find that the property has been brought into compliance based on the testimony and evidence presented by the county and Mr. Sawgrave's testimony. Based on the request and no objection by the county, I will agree that a fine reduction is appropriate in this case. Mr. Sawgrave's request of $2,000 will be denied, but we will, I will agree to reduce the fine to $4,500. In the event that the $4,500 is not paid within 30 days, the original amount of $42,525 will need to be paid. I'm sorry, I did fail. There is a $23 administrative fee that will also need to be paid, so the full amount for the fine reduction is $4,500 and a $23 administrative fee. Those will need to be paid within 30 days. Otherwise, the full amount of the $42,525 will be imposed or reimposed. Any questions from the county? All right. Any questions, Mr. Sawgrave, on the reduction? All right. Thank you, sir. Our next case is CE 25-01821. Property owner is Freeman Revocable Living Trust. Or, I'm sorry, Brenda Freeman Revocable Living Trust. The address is 159 Beacon Point Drive in Santa Rosa Beach, Florida. And this is not a fine reduction. So, is there a representative here for Ms. Freeman? Oh, okay. And who do we have for the Freeman Trust? Okay. And
Shannon Clatchy.
okay. All right. Whenever you're ready. I've got it. Go ahead.
Got it, okay.
Yep.
All right, I'm Code Compliance Officer Greg Forehand. For the record, I'm submitting my final summary report, presentation, and testimony in reference to case number 25-01821. The property is an unincorporated area of Walton County and subject to Land Development Code, Chapter 7, pursuant to Florida Statute, Chapter 162. Location, parcel numbers 242S214220 0010230, also known as 159 Beacon Point Drive, Santa Rosa Beach, Florida 32459, belonging to Brenda Salas Freeman Revocable Living Trust. Violations listed are 1.13.06. Post-permit changes, 5.00.03, building setbacks. The complaint was received on 10/07/2025 with research finding no approval for the additional pavers or upright fire pit in the backyard. With initial inspection made on 10/10/2025 and a courtesy hanger left advising of the visit on 10/13/2026. Notice of violation was prepared and placed in the mail along with posted to the property on 10/14, given until 12/9/2025 to bring the property into compliance. On 10/16/2026, I did make phone contact with Mr. Freeman, finding out they had moved to Texas, and advised him of the violation and potential means of resolve. And there had been many continued interactions between the Freemans, Planning Department, and Code Compliance, along with follow-up showing no changes in the removal of the items or submittals for approvals into the planning portal. Then on 12/22/25, notice of hearing was prepared for the February 11/2026 hearing, being placed in certified mail along with postings made on that date. Then on 12/30/2025, Ms. Freeman did have a pre-application meeting over the phone, planning to move forward with an updated survey to review for the impervious surface area and to request a setback variance consideration. And then yesterday, I completed a pre-hearing inspection, finding a survey crew present there at the property as part of the plan and moving forward. And the fire pit and pavers do remain at the property with no approvals or variance having been issued as of this date. I would like to submit my packet as evidence.
All right. Any objection? All right. With no objection, it'll be accepted. So I see the pictures of the fire pit.
Mm-hmm.
The only, and correct me if I'm wrong, the only issue would be where the fire pit begins to go vertical would be a setback violation, correct?
Yeah, the vertical area, but the pavers themselves, they were opposed to a development order change, and it's an impervious surface situation, and where the impervious surface has to be within a certain percentage, and planning has to evaluate that with a stormwater plan to make sure it doesn't go outside the surface ratio out there for the impervious surface drainage.
Okay. So what do we have to show that the setbacks have been violated? I don't see a survey or anything.
And that's it. There's nothing there to show it. To show there's nothing ever turned in for it to ever be. The additions were ever approved for anything. It looked like it was installed around 20 to 21. It was prior to them purchasing the property. And I discussed it with planning, and they said even though it was prior to their purchase, it would still need to be amended for it to be there. So.
And so the pavers are considered by planning to be an impervious
yeah,
surface?
They may not require permitting, but they do need to make sure they fit within the stormwater plan as the impervious surface percentage.
Okay.
For the property, yeah,
So,
for that parcel.
I guess what I'm questioning is where that might be appropriate under 1.13.06. What evidence do we have that the building setbacks have been violated?
Well, the upright portion of the fire pit is within the setback area.
Okay.
I mean, it's visibly within that. The owner did give me permission to go onto the property to measure it, and it does measure it like at 13 foot from the rear, the gate, where it has to be 20 foot from the rear. The rear setback on the rear gate. I mean, I'm no surveyor, but they did give me permission to go on there and measure it. Okay. And yes, sir. And Mr. Your name, sir? Clatchy. His survey crew was out there yesterday, and I'm not sure their exact determinations.
Okay.
On that.
Yeah,
yesterday.
and I'll hear from Mr. Clatchy. I had not that testimony that you had been out and measured. I'm assuming with a tape measure from the rear property line, or what you believe to be the rear property line, was how many feet?
13.
Okay.
Like 13.3 from the rear property line.
Got to be 15?
It should be, yeah.
Okay. Ms. Mahan or Mr. Well, I guess is Ms. Mahan, you handling this primarily? Do you have any questions for Mr. Forehand? Okay. All right. Thank you, sir. All right. Whenever you're ready, Ms. Mahan.
E. Mahan, M-A-Y-H-A-N-N, agent for Brenda Freeman. We do have a survey, and I've made copies for the county as well.
Okay, great. So I've been handed a packet, 4 pages it appears, from Ms. Mahan, and I'm assuming you want to put this into evidence?
Yes, sir.
Okay. Any objection by the county? I'll have her go through. Okay. Without objection, I'll accept Ms. Mahan's composite exhibit. We'll make this as Exhibit A for the respondent. All right, whenever you're ready.
Before I get started, I wanted to mention something about the Land Development Code, Chapter 5.00.03, under B, number 2B, states, this is regarding accessory structures and buildings, and there's an exception, except that decks and patios less than 2 feet above finished grade on all sides may be placed within the building setbacks provided they are not located within 4 feet of any property line. So Mr. Clatchy, which will come up and testify as well, his survey crew did go out on the property and measured the fire pit, which was 21 inches. And also the surveys that I've just provided will show that some of the brick pavers are, I believe, Mr. Clatchy can testify to this, maybe in the setback, but we may have an exemption. I wanted to bring that before you and see if that applies.
Okay.
And then a little bit of history. The house was built in 2011 by D.R. Horton and sold to Joseph Weems in 2011. October 2020, Weems sold the property. And then renovations were done in 23. There's a building permit number 23-8245, replacing windows and sliding glass doors by the owner, Palusco. The Freemans purchased the property in February 2024. They've made no renovations, construction, or other improvements to their property since their purchase, only cleanup of old debris and household items necessary to move in. The brick pavers and the fire pit were already in place prior to them purchasing the property. And then I noted the violation. The first one I'm a little bit confused about, the post-permit changes, because the Freemans didn't make any applications to begin with to make any changes since their purchase of the property. So I'm not understanding that one. The next is, because the owner had no knowledge that that was even built or in the setbacks or anything of that nature. They did order a boundary survey, which was completed yesterday. The remedy from the owner, if Magistrate Dykes, if you would allow, the fire pit, she's agreed to remove that immediately. But the pavers, she would like her back deck with the pavers, she would like to keep if possible.
Okay. So, do you want to have Mr. Clatchy
Yes,
come
please.
up and testify?
Yes.
All right, and the way I'll do it is, I'll just, if you want to ask Mr. Clatchy specific questions,
Okay.
as it relates, I'm assuming he's going to speak to the survey and the things found on property. So whenever you're ready.
It'll be good, Judge. Thanks for having us over. I would like to really respond to the ISR, which is as the impervious surface area. We did a calculation with the brick pavers, the residents, the porches, and came up with an ISR of 0.44% or 0.44 or 44%. So well within the 60% mandated by the county. So whenever these pavers were put in, in my opinion, the impact of the surface areas were not impacted very much. Also, I'd like to say the structure that is the fire pit itself, if it goes, my question is, if it's a vertical structure, but it has no footing, foundation footings, and can be moved away with a wheelbarrow, is that really considered a structure, or is this just an amenity to the patio itself?
Okay. So based on Ms. Mahan's statement, I'm looking at the code section. Is the fire pit 2 feet above finished grade on all sides?
Fire pit's 21 inches.
Okay. Now this says that except that decks and patios, so it doesn't, I mean, I think we'd all agree this isn't, while it's part of the patio, it's a separate thing.
Would the pavers be The pavers is the patio, correct?
Well, I would tend to
That's-
think,
that's what-
I believe, well, I mean, I'll decide that here in a minute, but I'm just saying that the way the code, the way I read it here, it says that, except that non-elevated accessory structures such as walkways, and at-grade patios or decking, that's A. Then it goes, except that decks and patios less than 2 feet above finished grade. And I think that's the one that you were pointing to. So I think if the deck or patio, which could be made out of wood and maybe elevated, 6 inches above grade, then that would be an exception under here. But it doesn't state that any accessory structure, or doesn't specifically say fire pits or anything.
Meaning the fire pit, correct?
Right. So I think you would still have that issue, and your testimony is that the intent from the property owner is to remove the fire pit.
Correct.
At this point. Okay, so that may tend to resolve that. And then, Mr. Clatchy, you probably do know better than me, but I'm going to ask the question. So you've done an analysis related to the impervious surface area. Based on your analysis, it's at 44%, well below the 60% allowed by the county. How is that transmitted to the county for their review to confirm that your analysis was correct? And yes, we agree, therefore there's no need for a permit or anything like that.
I didn't actually get the calculation, the worksheet done until 10 o'clock last night, so I didn't have an opportunity to send it, but I shall once I return to the office.
No, I understand. I'm just saying, is that the process though? You turn in your calculation or worksheet.
Oh, absolutely.
Then
Yes,
the
sir.
county reviews that and they do their own math, I'm assuming, or they check your math, whatever you want to say. And then at that point, they will either send you some sort of notice, or the property owner a notice that, yes, we agree, or we're satisfied with these calculations.
Yes, sir. That's, well, as a procedure goes, I just didn't have a whole lot of time from when we got to get the go-ahead to do the survey and to calculate the ISRs. I just didn't have the time, but.
Yes, sir, that's our procedure. That's
Yeah,
what we'll do.
yeah, and I'm not trying to beat you up over timing. I'm just trying to think through my mind, what would be the timing and turnaround? Is, say you submitted that tomorrow to the county through their portal, I'm assuming. Is that something that gets a pretty quick
We
turnaround
could
time?
definitely do that, but that would be up to the county then and on the portal and how quickly they could get the review process done.
Okay. And then assuming that's submitted to the county, reviewed, and approved, there would be no requirement to seek a permit at that point, correct? It's just that we've approved it, we're good with that, it gets filed, and is that done? Or is there some sort of?
To my knowledge, that closes the case, then it should be finished.
All right. Okay, anything else from either one of you?
Have any
No,
questions?
No, I think you've answered all my questions. I appreciate it. Thank you.
Thank you.
Let me make sure, Mr. Forehand. Mr. Forehand, did you have any questions for Ms. Mahan or Mr. Clatchy regarding my questions?
No, sir.
Okay. Anything else from the county?
No, sir.
All right. And I'll give one last opportunity for the property owners, representatives, Ms. Mahan or Mr. Clatch. Anything else you want me to consider before I close the evidence portion? All right. Thank you both. Thank the county. I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 159 Beacon Point Drive in Santa Rosa Beach, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find that there was sufficient evidence to show that there was a violation of 5.00.03 building setbacks and 1.13.06 post-permit changes. While I understand Ms. Mahan's testimony and argument that the prior owners caused the violation runs with the property, not necessarily the owners. So just because an owner sells property and leaves the state does not mean that they are absolved of a prior owner's actions on the property. What I will say, though, is I do find Mr. Clatchy's testimony and Ms. Mahan's testimony and argument persuasive, and it sounds as though the violations are in the process of being mitigated. So with that being said, I'm going to find the violations have occurred at the property. To my understanding, they have not been resolved yet, correct? They have not been, we don't have the fire pit removed, and we haven't submitted the ISR report, pervious surface report to the county, but I understand that's forthcoming. So I'm going to give the property owner 90 days to bring the property into compliance. So that would be on or before May 12th. In the event the property is not brought into compliance, Mr. Forehand, I didn't see a recommendation, or did you have a recommendation that I just missed related to it?
Yeah, it was gonna be $150 a day.
There will be a $150 per day fine imposed if the property is not brought into compliance on or before May 12th. There is a $73 administrative fee that will need to be paid within 30 days. I will also make the finding that based on Ms. Mahan's request, that if the impervious surface ratio is as Mr. Clatchy testified, the pavers can stay. And then I'm assuming filling in the area where, if there's even needs to be fill-in where the fire pit currently is, because I'm assuming there's a bottom on it that can stay as well. But but that'll have to be confirmed through the county, because I don't believe that. I do note that that's there. Obviously, if there's a separate code case, we'll just have to deal with it at that point. But I mean, to me, I'm not going to order you have to remove anything if the county confirms that's not required. All right, 30 days to pay the administrative fee, 90 days to bring the property into compliance. Have I missed anything? All right, I'm going to sign this order. Any questions, Ms. Mahan, regarding the order? Yes. All right, thank you both, or thank you all. I've signed that. Y'all are dismissed. Our next case is CE 25-0-1800, and that property owner is listed as Christian and Paige Shanholzer, and the property is Lot 10, Block B, Pisces Cove. I believe that's in Santa Rosa Beach. Is someone here for Shanholzer? Mr. or Mrs. Shanholzer?
Morning, Your Honor.
Morning.
Officer Harold Serrano, Walton County Code Compliance. For the record, I'm submitting final summary case report and testimony for case 25-01800 on behalf of Officer Justin Sloan, who has transferred internally to short-term rental. Property location, Lot 10, Block B, Pisces Cove. First ad, Virgo Street. Parcel number is 192S19243100B0100. Property owners Christian and Paige Shanholzer. And property is in the unincorporated area of Walton County and is subject to Land Development Code Chapter 7 and the county ordinance. Violations cited, 1.13.00A, development approvals, and 1.13.09C, building permit. Complaint on 10-1 was clearing property without permit and fill dirt brought on site. On October 2nd, 2025, Officer Sloan conducted an initial inspection, observed the property cleared without permits and fill dirt had been brought in. A stop work order was placed on the property at that time. On 10-3, Officer Sloan posted a notice of violation on the property and sent the property owners a notice of violation via certified mail with a compliance due date for November 6th, 2025. On December 2nd, Officer Sloan sent an updated notice of violation to reflect the building permit required for the fill dirt that was brought in to the property owners. On 12-3, the updated NOV was posted to the property, and on 12-4-2025, Officer Sloan received the proof of the acceptance from USPS for that updated notice of violation that was sent. On 12-18-2025, contact was made with the property owner's sister, stating that they are close to having plans done to turn into planning, and asked if we could give them an extension. She was advised by Officer Sloan that if an application was submitted on the planning department to the planning department, an extension could be granted. However, shortly a month later, on January 9th of 2026, a follow-up inspection was conducted and found no change, and no applications were submitted to planning department. On January 20th of 2026, a notice of hearing is posted onto the property, and a certified mail copy was mailed to the property owner, which was received and signed on 1/21/2026. As of February 6th, 2026, a planning BPR application was submitted to planning and is still under review.
Sorry, what was that date again?
February 2nd, Your Honor.
All right, thank you.
I would like to submit my packet of evidence at this time.
That'll be accepted.
Property has not been in compliance within the allotted time, and at this time is requesting that the property be in violation.
All right. I didn't see anybody come in, so one last time, any representative for Shanholtzer here? All right. What's the county requesting as far as time and to bring the property in compliance and fines?
Request 30 days to achieve compliance, 250 days per fine to occur, and a $73 administration fee, Your Honor.
All right, thank you, sir.
Thank you.
So I don't know that it's going to be hard for them to get into compliance within 30 days. But, all right, I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property generally described as Lot 10, Block B, Virgo Street in Santa Rosa Beach, Florida, with a parcel ID number 192S192413100B0100 is in the unincorporated area of Walton County, Florida, and is therefore subject to the Land Development Code. Based on the testimony and evidence presented, I do find that sufficient evidence to show that a violation of the Walton County Land Development Code exists on the property, specifically 1.1300A, development approval, and 1.13.09, building permit requirement. Based on the county's recommendation, I will order a $250 per day fine. I will order that the property needs to be brought into compliance. I doubt they'll meet this, but I'm going to double the time requested just in order to give them a chance. What's 60 days out? All right, so they'll get 61 days. So April 13th. If the property is not brought into compliance on or before April 13th, 2026, a $250 per day fine will be imposed. There's a $73 administrative fee that will need to be paid within 30 days, regardless of whether or not the property is brought into compliance. All right, did I miss anything?
Nope, thank you.
Good, all right, thank you, sir. Last case, CE 2501-569. Property owner is listed as India Estrada, and the address is 9605 County Highway 183 in Ponce de Leon, Florida. Good morning. Are you, I also have on here, well, at least on the draft order, Teresa Grandinetti. Okay. Who are you? You two?
I'm her daughter. I'm Jenna.
So you're India? Okay. All right. We'll allow the county to present, and then as we've been doing the others, we'll allow you to ask questions or present any testimony or evidence, all right? Right, whenever you're ready.
Good morning. For the record, I am Walton County Code Compliance Officer Uriel Baza. I am submitting my final summary case report and testimony regarding case number CE 25-01569. The property address is 9605 County Highway 183 South. Parcel number 29-3 North 06000-015-0000. This property is in the unincorporated area of Walton County and is subject to the Land Development Code Chapter 7 and the county ordinances. The violations cited are 2.0200P, RVs and campers, and 5.07.09C, exterior storage of non-operating vehicles, junk or debris. We received the complaint via phone call on June 30th, 2025. RV set up 10 feet from the road, junk and debris and raw sewage coming from RV. Complainant also said the RV is set up in the lot beside the house. My initial inspection was conducted on July 7th, 2025, where I observed an RV with hoses connected on one side and several items throughout the property, including tires, a refrigerator, trash, and buckets, just to name a few. On July 8th, 2025, I made contact via phone call with one of the property owners. Her name is Teresa Grandinetti, where I explained the complaint, the condition of the property, and the required corrective actions needed to bring the property into compliance. On July 9th, 2025, a notice of violation was sent certified mail and posted to the property the following day. Ms. Grandinetti does not reside in the home and currently lives out of state, but made tremendous efforts to collaborate with the individuals living in the RV to bring the property into compliance, providing considerate extensions. The property neared compliance, but efforts halted as the final extended deadline concluded. On December 22nd, 2025, a notice of hearing was sent certified mail to both property owners. On January 14, 2026, the notice was posted at the property and South Walton Courthouse in accordance with Florida Statute Chapter 162. As of today, violation 2.02.00P is resolved, but violation 5.07.09C still exists on the property. Photos in your packet show the initial inspection and the pre-hearing conditions, with violations still existing. I would like to submit my packet into evidence.
Any objection?
My daughter speak for me because I have.
Okay.
So
Well,
she's
that's fine. What I'm gonna do is All I'm asking is, do you have any issues? I'm gonna accept this into evidence. I was just gonna give you the opportunity if you saw something or wanted to bring something up, like, that's not our property, or that's not our.
I'll go ahead.
Yeah, I just need to know at this point, do you have any objection?
Oh, no, sir, I don't.
Okay, great. I'll give you a chance in a moment. Okay, so that'll be accepted without objection. All right, anything else? All right,
No, sir.
now this will be an opportunity if you have any questions for Officer Baza. Do you have any questions for him specifically? Okay, come on up. Yes, please.
I do. The concerns, I'm sorry.
And state your name for the record, ma'am.
Jenna Estrada.
Okay.
The shed is the only remaining structure and is located within the previously approved fence boundary. If anything further is required regarding the shed, we're willing to comply.
Okay. Is that a question?
I mean,
Yeah.
it kind of is a question.
So your question is to Officer Estrada, is that the only outstanding violation?
Because it was previously, like, the location of the shed is exactly where the previously allowed fence was for a privacy fence that my husband built. And because, like, the RVs and campers and all that, my husband was renovating one of them. So that's why there was kind of like, you know, a mess out there, but they're all gone now. Like, there's nothing out there.
So, the way I interpret the question, officers, is there, what are the outstanding, to your knowledge, what are the outstanding violations under 5.0709C that they need to resolve?
Yeah, so yesterday I did my pre-hearing inspections and everything did look a lot better than
Yes, sir.
than it
Thank
did.
you. I appreciate
For sure, I
it.
definitely appreciate y'all's efforts on getting it into compliance. But by the house, so I know mainly the focus. So the property includes the house and mainly the area that you guys were mainly focused on,
Yes.
right next to it.
Yes, sir.
But it's all one parcel.
Correct.
So yesterday when I went out there, that part actually looked pretty good, other than the shed that was brought in. But by the house, there's also a washer and dryer.
Yes, sir. We're moving that today.
That would probably be the main concern. I have that
Okay.
removed immediately because.
Yes.
All right. And the way it would work is once you believe you're in compliance, then you call the county. They'll come out and do another inspection and
Yes,
kind of
sir.
give you either a clean bill of health, or they may say, you're 95% there, you got to do these couple things,
Okay.
and then we can get you done. So that's generally correct how it would operate to bring the property fully in compliance.
Thank
Okay.
you.
Do you have any other questions for?
No, sir. I believe that covers
All right.
everything.
Thank you.
Thank you.
Do you have any evidence or testimony?
I'm no, not really. No, sir. I'll just leave it at that.
Okay, great. What's the county's recommendation on this?
All right, so recommendation is to bring the property into compliance by March 16th, 2026. That's going to be 33 days. The 30 days is usually our typical recommendation, but it falls on a Friday, and I will not be able to perform that on a Friday, so preferably on a Monday, which would be March 16th. So you guys brought the RV issue into compliance, so hopefully
Yes.
that can stay and remain.
Yes, sir. We're moving actually
Okay.
to Freeport.
Okay, so as long as that doesn't come
Yeah,
back,
that won't arise.
that will
again.
be in compliance. And then the other thing, like I explained earlier, is just getting rid of the washer and dryer appliances that you have outside of the home. Once you bring that into compliance, then it'll be, just like he said, just let me know. If it doesn't come into compliance by the 33 days, then it will start accruing fines. We recommend, as the county, $150 per day
Yes,
accrual.
sir. Okay, we'll be in compliance by the end of the week. Before the end of the week.
And then the property does also have a $95 administrative fee.
Okay. Thank you. Thank you both. Y'all can grab a
Thank
seat. All right. I'll go ahead and close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 9605 County Highway 183 South, Ponce de Leon, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find sufficient evidence to show that the property presently has a violation. The violation proven today is 5.07.09 exterior storage of non-operating vehicles, junk, or debris. Based on the county's testimony prior to the hearing, 2.02.00P RVs and campers has been resolved. I will find that violation previously did exist at the property and has been remedied, so there will be no fine related to the RVs and campers. However, any future offenses on the property of the same nature will be considered a repeat violation and could be subject to additional fines. So what that means is if you get everything cleaned up, you wait a couple months and you start bringing RVs and stuff back out there again, then they're not going to have to give you the amount of time that can bring that immediately to hearing and start accruing fines. So just be aware of that. But there will be no fines, and there's no finding that you're in violation of that today. So the only issue that you have to resolve is the exterior storage of non-operating vehicles, junk, or debris. Based on the county's request, I will provide that the property be brought into compliance on or before March 16th, 2026. In the event the property is not brought into compliance on or before March 16th, 2026, a $150 per day fine will be imposed. In addition to the fine, there's a $95 administrative fee that will need to be brought into need to be paid whether or not the property is brought into. So if you bring the property into compliance tomorrow, you still got to pay this $95. Okay, can you pay that within 30 days? All right. I'm just writing some notes on the order that there was no violation at hearing found as to 2.02.00P RVs, but did mark the box and list that in the event there's another violation related to that can be brought as a repeat offense. All right. Do you have any questions, Ms. Estrada, regarding the time, the order, anything that I've gone over this morning? Okay, great. Do appreciate you guys taking this seriously and taking steps to remedy. Sounds like you're almost at over the finish line. Just got a couple more things to do. All right. Anything else from the county on this case? All right. That concludes that case. And I don't have anything else on the agenda, so unless there's anything else, we're adjourned.